There we go. Good evening, everyone. Welcome to beautiful downtown Grand Forks. This is Grand Forks City Council's Committee of the Whole for Monday, May 24th. Under item 1, call to order. 1.1, welcome and roll call.
Weigel.
Here.
Dockler. Weber.
Here.
Mock.
Here.
Kwame.
Here.
Sandy.
Here.
Veen. We have a quorum.
Excellent, thank you. Under item 2, discussion items, 2.1, special events, noise variance and letter of intent for commingling during Greenway takeover. Good evening.
Good evening, Council President Sandy, members of council. I'm bringing to you another commingling noise variance approval. That is for the annual Greenway Takeover event, which happens in September 9th to the 12th, along with Kate Slominski and her general manager, I believe, or owner from the Bun are here, and they would like to hold the event and serve alcohol.
Any comments or questions, Mr.
I'll move
Weber?
approval.
Moved by Weber, second by Weigel. Any other comments? Hearing none, all those in favor signify by saying aye.
Aye.
Opposed, same sign. Motion carries unanimously. Thank you. Item 2.2, special event. Request to waive City Code Section 9-0307 related to swimming in the river for extreme water sports endurance test event, June 9th, 2021. Ms. Simeone, thanks.
Yes, this is another item here for us to be able to swim in the Red River. It's an annual event. It's from END Extreme North Dakota WET, which of course is Water Sports Endurance Test Event, and it will be June 19th. They do some preliminary testing with swimming and just getting acclimated to what they need to in the water, but it is a process that they have completed all of the paperwork that the city has asked of them, and they also have completed the work with the Grand Forks Sheriff Department, who would be the ones who really manage the river.
Great, thank you. Any comments?
It's a great event. Happened. This is our 5th year, I
Yes.
think, and brings folks from all over the country and beyond.
Has anyone drowned yet?
Yep. No.
Nobody drowned? That's good.
No, and they actually will be finishing, I believe, this year at the boathouse, so we'll be seeing more action in our town.
Great. Okay, so that's a motion by Weber.
Second.
Second by Kwame. Any other comments? Hearing none, all those in favor signify by saying aye.
Aye.
Opposed, same sign. Motion carries unanimously. Item 2.3, appoint Adam Helgeson to the Board of Adjustments. Anyone want to appoint Mr. Helgeson? Moved by Weigel, second by Mock. All those in favor signify by saying aye.
Aye.
Opposed, same sign. Motion carries unanimously. Item 2.4, review of city code relating to alcohol licensing. Mr. Gostad.
Yes,
Good evening.
thank you. Good evening, Council President Sandy and council members. I thought what I'd do is just go through hopefully everybody got a copy of Article 2, which is the alcohol ordinances in total. And what I did is I reviewed the ordinances and went through and looked at changes that were done legislatively in the last session. Also some changes for the council to consider. These aren't proposals. This is not a recommendation on my part. It's as I understood, a method to get the conversation moving. So I have some direction as to what you want if there's going to be a first reading at the June 7th meeting, if any ordinance changes. So what I thought I'd do is just go through each one numerically here, starting with the definition of beer. That's in 210201. That is just a change that was done by the last legislative session. I think it was more of a taxing issue so that they pick up the Trulies or whatever and make sure they're taxed as beer, just to be consistent. We would adopt the same language. Also in the definitional, I added for the term person to include other various types of entities, limited liability partnerships, things like that, would be deemed to be a, quote, person for purposes of, when you use the term person throughout the code, it would mean all of those types of entities. So those are basically just clean up languages that are being proposed. The next is at 210205.
Mr. Gostad, can we
yes,
hold on
sorry.
a second? Does anybody have any issues with those updates? Great, thank you, Mr. Gostad.
Sorry.
No problem. We may as well get that over with while we're moving.
Those are easy ones. The next is at 210205, and hopefully the pages are the same. This would be at pages 6, and then 17 and 18. There are a couple of licenses that are evidently either aren't being used anymore. The excursion boat alcohol beverage license hasn't, as I understand, hasn't been used. Actually, I was on that excursion boat pre-97 in college. It was a great time, but they don't have it anymore. And then the service convenience minibar, I understand it's never been issued. So what we'd propose to do is simply repeal them, but use it as a placeholder so that if we ever needed to bring it back or have another license, we'd have a, quote, Class 10 that just doesn't have anything to it at this point. All right.
Anybody have any issues with repealing those licenses that aren't being used? Questions? Sure, Ms. Mock.
Mr. Gosta, do you see it as better to repeal them or to just leave them in place even if they're not being used? Is there...
I guess it doesn't make any difference from my perspective.
Okay.
It makes no difference other than we've got licenses that just simply aren't being used.
That aren't
And as
being
I
used. Okay.
understand some of the discussion, at least with hotels, the minibar deal is more pain in the neck to maintain than it is to have it. So I just don't see that ever coming back. The excursion boat, you never know if somebody wants to use that, but if it ever comes back and somebody wants to have that type of business, it'd be pretty easy to reinstitute it.
Okay, any other questions? Okay, thanks, Mr. Costa.
All right. The next is, there is a new type of license that was passed by the legislature, and it's actually effective today. It was passed by an emergency clause, so it's effective now. It's the manufacturing distillery class, and I've identified that would be Class 17. And if you turn to page 23 of the document, it lists the types of, the parameters of that particular license. One is, and this is really, I parroted what came out of the state statute. So most of these regulations are derived directly out of the state statute. They need a state license. They can give samples, but I've cited to the Century Code as to the means and methods of giving samples. The hours of sales are the same for all other license holders, except that the state law said for Sundays it had to be between noon and midnight. So we've adopted that. It said subject to local ordinance, so I suppose you could make it longer if you wanted. I just tried to keep it consistent with what the Century Code was. They can have a satellite location where they can have samples and then also on and off sale types of alcohol sales. The conditions are, one, that they have a retail license for that particular satellite, the location, and then they follow the state law requirements, which is they can't have production at the satellite. The satellite location either has to be owned or leased by the manufacturing distillery, and there aren't any wholesale activities there as well. Also, they can have a restaurant at that satellite location, so I've included that language. And by state statute, they cannot be a domestic distillery, so they can't, reference to Class 12 as our domestic distillery. Not sure why, but that's the way the Century Code was set up.
Mr. Weber.
If I may, on Class 17, Item C, I'm imagining it's conceivable that these folks could want to serve a brunch on Sundays. Is it that kind of business, that it could be restaurant as well, or is this only manufacturing?
That would be at the satellite location.
Okay.
So they can have a manufacturing distillery and then have a satellite location where they'd have their restaurant located.
And Sunday hours would conceivably be different for that satellite?
Correct, because that would be on sale type of alcohol sales.
Very good, thanks.
Great. Any other questions while we're on the topic? Okay, thank you, Mr. Gostad.
All right. Next is, this is at pages 8 and 10. This deals with the Class 4. What I tried to do is to better define what a restaurant is, or a food establishment. And so I've added language that in order to be a Class 4, you have to be a restaurant as defined in our, another section of our city code is 210701, which is a building or other structure that's held out to where meals and lunches are served, but sleeping accommodations aren't furnished. So I tried to parrot and incorporate in the language of what a restaurant is for restaurant licensing purposes. And also that there's a designated and permanent kitchen where there is food prepared, and then the employees serve that prepared meal on site. The language about multi-course meals, steaks, fish, seafood, etc., that seemed strange to me too, but I looked in Fargo and they have the same language. Fargo and mine have the same language. What I tried to do was to exclude, though, a mobile food vendor or those where there is pre-prepared foods where it's just heated. So a Class 4 is a little bit higher level of a restaurant. Okay?
May I ask a question there? This was an important one. This is one of the issues that sparked this whole review of our code.
Yeah.
So what happens to a business that is currently operating under this?
It would be effective, well, they have a license now, so it would be my thought that they would operate under the current license that they have. I don't think we could change the rules midstream.
Very good, thanks.
And you could always make these effective at a later date, January 1 of 2021, or 2022, excuse me. Because the license holders are good for a calendar year to avoid any of the confusion. The other thing is we changed the criteria that as to when somebody can be in the facility for Class 4. You could be in there as long as who doesn't order, no liquor sale can be made to a customer who does not also order at least one food item, or not more than 50% of the annual gross sales are derived from alcoholic beverages. It was a lower threshold, so it actually loosens it up a little bit. You can have more alcohol sales and still be in there without ordering a meal in a Class 4 facility. Also added some language with respect to certifying their alcohol and food sales, so there is some teeth to it, so to speak. And also to the extent that the city may also get it under penalty of perjury from their certified public accountant.
Comments? Yes, Ms. Mock?
So what happens if you've operated under that license the whole year and then you don't meet that 50% sales? Is there a penalty, or?
You probably wouldn't get the license for the next year, would be
Okay.
my expectation.
So
It would be
as a-
hard to go back in time.
But we would expect them to be honest with us.
Right.
And apply for the liquor license that they would actually fall
Fall
under.
under?
Yeah.
Okay, so then that would just be
I think that would be considered as to whether they'd get a license for the upcoming year.
for the next year?
Yeah.
Okay.
Yeah, Mr. Weber?
And who polices, monitors, tracks that?
Not the city attorney's office, but somebody, I would expect probably Sherry would be the
Yeah,
one that would be
Okay.
working with them.
President Sandy, Councilman Weber, members of the committee. Those reports are submitted to the finance office, and if there is a conversation about coming very close to that percent, we work with them, and it would be the year following, but we try to keep it as close to meeting that requirement as possible.
Very good, thank you.
Thank you, Ms. Dorstad.
All right. The next change, you've seen this one already before. This is the gaming provision. I've added it back in. Again, there is that 800 square foot area that a Class 4 can designate where only those that are over 21 can be within. And that designated area could then be used for gaming as well. I didn't include, there'd have to be a change to City Code 90404 as well. I didn't include that, but it would be the same changes that you've seen before.
Any comments or thoughts about the gaming language? I think it's relatively straightforward. I don't know if everyone agrees with it, but the language is straightforward. Okay, thank you.
All right. The next change is with Class 7. This is golf courses. This is more of a cleanup. This is on page 13. More of a cleanup just to cite to the city code that references when these can be operated rather than it just seemed odd to me that it was in there. We've already got a ordinance that deals with when alcohol can be sold, and just cite to that one. The next change is at the Class 11. These changes are as a result of House Bill 1284. That becomes effective August 1st. So this would be an example where we make this particular provision effective August 1st of 2021. And really what they did is remove the requirement that it only be beer and wine, and now it's all alcoholic beverages for a special event as to when minors can be present. Again, this parrots language from the statute.
Any questions? Okay.
Next is a minor change in Class 16. This is again consistent with the Senate bill that was passed to remove less than 12 ounces in the language. That was removed by state statute, so to be consistent, I did the same. The manufacturing distillery, I think we've already talked about that, those changes. Next is 210206 at page 25. To add language that you haven't been convicted in the last 5 years. The state application asks if you've been convicted of a misdemeanor or felony within 5 years. The state statute also makes reference to whether you've been rehabilitated, and you're deemed to be rehabilitated if you haven't been convicted within 5 years. So to be consistent or somewhat consistent with state law, that language was changed so that if you've been convicted 6 years ago, you wouldn't have to provide that information. The other language is just to add not just partnerships, but limited partnerships and other types of partnership-type entities that now exist under North Dakota law.
I apologize. Could we go back to the previous issue?
Sure.
All ages had been just beer and wine. Now it's liquor as well. Can you give me a sense of where this would apply?
Special events. I think the one you just probably approved tonight would be an example of a special event where they could have mixed drinks with minors present. Before it was just beer and wine sales.
And so if a currently operating bar rents out their facilities for a company Christmas party, then would that apply to this situation?
A private Christmas party, I'm not sure if they would need to get they probably would need to get a special permit in order to have those minors present. I didn't look at it and think of it in that context. I was thinking of it more in the context of an event downtown, those type of special events. I didn't think of it in that context at all.
All right, thanks.
I could certainly have the answer for you by the June 7th meeting. How's that?
Okay, yes, please. Thank you.
That's it. I think, correct me if I'm wrong, but I think we've wrestled with the concept of brick and barley or a bar closing for a Christmas party, and it's been, no, they can't do it because of the liquor that they have in the establishment. So I don't know if this changes that.
It very well may change that issue, because if they get a special permit, that's what they'll be operating under, not under the Class 1 license. They'd be operating under this Class 11 special permit license.
Sure, I'm certain they would be happy about having that option.
But every application would have to be reviewed by the council?
And they'd have to pay for that special license
Sure.
as well.
Okay, interesting. I don't know, is that a state law change?
It was.
Yeah. Right. Mr. Weigel, did you have a question?
I was going to go back to the felony / misdemeanor. It looks like state law has felony or misdemeanor. Looks like we're just having ours felony. Do we want to add misdemeanor into that?
That's on page 25, correct, Mr. Weigel?
Correct.
Thank you.
You certainly could.
I just can think of some misdemeanors that we might want to know about, that, or charged felonies and pled down to misdemeanors. I think that might be nice to know.
So, but that's, how do you add that language in? Because this says they must not have been convicted of.
Yeah, and so what you'd do is you'd put in convicted of a felony or misdemeanor within the last 5 years, is the way the
Right,
language
but
would be.
that's absolute though, isn't it? Because what Danny's implying is there are some that we wouldn't want them to get a license in, but not necessarily all of them, right? So I don't know, you're the attorney, you figure out how to put that language in there.
So I need to know which misdemeanors are okay and which ones are not okay.
I could probably get you a list.
Huh?
I could probably get you a list.
That would be perfect, yeah. And afterwards, if you have thoughts, please share them with me, because these are something to assist me in drafting.
Mr. Weigel, you'll have that to the city attorney within the next month, or
Tell them
less.
5 minutes after the meeting.
Great, okay, good. Thank you, Mr. Gosta.
All right.
Any other comments about the 5 years, the felonies? Okay, thank you, moving on.
The next change is at 210207. Evidently, social security numbers are no longer needed to do the background checks, and it just seems logical if they're not using it, might as well exclude them. Yeah.
To go back to Mr. Weigel's question, doesn't North Dakota Century Code 50202-3 already take care of that for us?
But we're a home rule city, and so we could adopt something that is different than what the Century Code is.
That language seems to imply something along the lines of what Mr. Weigel was referring to. That the Century Code makes reference to not being convicted of an offense that would have direct bearing on an applicant's or manager's ability to serve public alcoholic beverages unless the person is rehabilitated, which then references not having been convicted within the past 5 years. And the state application asks if been convicted of felony or misdemeanor in the last 5 years. So it seems that some of that work may have already been done in Century Code.
Yeah, I'm just trying to find the,
But I don't need to be micromanaging that conversation there.
Some of it does, Mr. Weber, but
yeah, it doesn't, the Century Code talks, I cited it verbatim, and it talks about it has a direct bearing on the applicant's or manager's ability to serve as determined by the Attorney General. So there may be, it's,
As a home rule
Pretty
city, we
discretionary.
may want to do that on our own.
yeah,
Very good.
and if you wanted to be precise, by being precise, that may be a problem, right? Because there might be a misdemeanor offense that you find is problematic, right? And if you have that precise listing and it's not within that listing, now all of a sudden it doesn't count. So we might want to be a little bit more broad in our language with that said, somebody's going to have to make that decision.
Thanks.
Perhaps people that have been convicted of a misdemeanor could put in their application, and then it can be determined through review by the city attorney.
And I would be good with that. I just think it's good to know if it's somebody that's
Sure, as long as they make us
habitual
know,
offender
make
of
it
domestic
known,
violence.
right?
Yeah.
Make it known and then do it right.
In my estimation, disclosure is 90% of the battle. If they disclose it and they tell you honestly that they've had this problem in the past, at least you've got that information. It's the folks that don't disclose it that becomes more problematic.
Right. Okay.
All right. The next one is 210211. I read the existing ordinance, and I had to read it a number of times to figure out how does it apply. Because the way I was told is that you can have 2 licenses in a particular class. So I could have 2 in Class 1, I could have 2 in Class 2, 2 in Class 3. But it's being applied, it's the attribution rules and how you count those licenses. And the way I understood it is that if it counted against other family members, immediate family members, so I drafted it in such a way that it would be, if I have a license, it's as if my spouse comes in and wants a license, she's already got one counted against her for counting purposes only. My children would have that as well. Also, my parent would be deemed to be counted as having that license as well. And then for each partnership that I'm involved with, my law firm would be deemed to have that license. Or if for each corporation that I have a 1% or more of the outstanding shares or other organization, they'd be deemed to have that license as well. Now, the 1% probably makes some sense, but I'm not sure even 1%. It seems to me that you should treat a partner the same as a shareholder. And so if you have any interest, something to consider, whether it's 0.05%. And so then I went the other direction, and so if the applicant or license holder is a partnership, then all the partners are deemed to be counted as having that same license. The same thing with the corporation. I found it interesting that the existing ordinance also said that each employee, so if you work in 2 separate license facilities, you can't get your own license if you're an employee. That's the way the ordinance was crafted. And then I made sure that the ownership would be both by direct and indirect. So if you create a bunch of parent and subsidiary corporations, it's all going to be counted through the process. I also wanted to make sure that this was only for calculating the number of licenses, not to create any ownership interest or claim an ownership interest in the license itself. That would still be with the license holder. So it's a lengthy change, but it was meant to clean up and clarify things.
Mr. Weber, question?
So at least 2, maybe 3 times you refer to having 1% or more, but you've just suggested having any interest may be the better way to go.
Correct. And the reason I use the 1% is because that was the existing percentage that was in the ordinance.
I'd be comfortable with going to having any interest rather than that designation. I don't know that it's going to make that much difference, but yeah.
So, Mr. Gossett, just so that I understand correctly, you've tried to clarify the way the rules have been applied.
Correct.
So what you've written is essentially what we've been doing anyway.
Correct.
Right, okay.
Which means this has been a good exercise.
It's been a mental gymnastics exercise. I went back to stock attribution rules in the Internal Revenue Code to come up with this language, so.
So can I ask a question? I mean, and I understand the concept behind counting, a parent having a Class 1 and my trying to have a Class 1 and it counting against me and them. But I'm not 100%, I mean, I understand it, I'm not 100% sure I agree with it, simply because there are plenty of parents and siblings or children that don't associate their businesses to one another. And so is it unduly punitive to people for being entrepreneurial?
And President Sandy, the language in the ordinance said immediate family, and I don't have no idea what that might have meant. And so I tried to define what immediate family might be. And if you want to reduce what that is, to take out parent, that I don't have any problem. I tried to define what immediate family would be.
Yeah, Mr. Kavami.
So there's no appeals process, I imagine, right? It's the rule is the rule, right?
Excuse me?
There's no appeals process if I'm disenfranchised from my parents but would wish to open a liquor store.
Oh, I think that if you came in and said I was disenfranchised from my parents and I was on my own, again, these are issues that it's ultimately the city council that has to decide on this. And so the city council could waive that type of requirement in those type of set of circumstances.
But I would assume the city council wouldn't want to do that, though, just because the rules are the rules. And the minute we do it for one, how do you not do it for all?
Yeah, you become a family law court at some point.
Siblings are not mentioned.
They are not. And they could be, but they are not.
Right, siblings aren't, my aunt and uncle aren't listed, but I know lots of people whose aunts and uncles support them quite significantly. So, it's interesting, of course. Again, I understand the lineal relationship between parent and offspring, but, yeah. Honestly, I had no idea that that's the way the rules have been applied. Did anyone else know that counts against? Have we ever run into a circumstance where an offspring is applied for a second and they have been denied because a parent has a liquor license?
President Sandy, no, I don't think that we've specifically had anyone, but we have run into cases where people have called that are maybe part of a partnership or a corporate entity, and they've wanted to get a third business within the same class, and they've been told no due to their partnership. I think usually with families, we more see where it just passes down from father to child when they've come in.
Okay. Any other questions regarding that?
I'd support getting rid of the offspring or whatever we call it. What do we call that? Child.
Child?
Yep,
Yeah.
I'd support getting rid of that. That's just my opinion.
And keeping parent?
I think spousal makes sense. I think parent, offspring, parent, child, I don't think that makes sense. But if we run into it, I don't know. I don't know that having these rules on just for the sake of having the rules on makes sense either, so.
Yeah, Mr. Weber.
The intention here is to close possible loopholes so that a family could end up with 12 licenses of the same class.
Yes.
That's the intent here.
Yes.
But we could pause that, right? And we could stop that if they came and applied for the fourth one and we're like, okay, your brother now is opening a liquor store. We have the ability to say no, right?
You do have the ability to say no,
We also
except if you meet all the other criteria. If you meet all the other criteria, then it becomes, why did you deny the license?
You're picking and choosing. Winners. Picking
I
winners.
rescind my previous statement.
But would it be so bad to have a family with 5 off sales?
Well,
I mean, would it? I don't know.
I I could be the de facto owner and farm out a bunch of licenses to family members and give them a percentage and pretend that they're the owner when I'm in fact the owner. And now suddenly I have five classes of the same license. And
Philosophically, is that bad too?
Yes.
Okay.
Yes, I think that's been, at least, that's been the intention of the council the whole time that I've been here. And I'd been convinced that that was a good thing. I thought that you would convince me that that was a good
Yeah,
thing.
I'm just asking the question. I waver on these things all the time simply because life changes, life goes on. I don't know.
In
Today.
your more convincing moments, you convinced me that
Right,
that was a
very
really
good.
good idea.
Very good.
If someone wanted to get around it, I'm sure they could get around it. I feel
I don't
like,
think they can.
I think if they remove themselves from it, or, I don't know, but that's fine, we'll just leave it.
I think if you want to have a retail off-sale establishment and you have two already, you could perhaps open a small beer bar and then have a very large off-sale. You could do that. But you have to staff it, and there are all sorts of reasons why you wouldn't want to do that. I don't know, yes, Mr. Weigel?
I'm just trying to process all of this. So my mom and dad could own 2 off-sale liquor stores, and I may not communicate with them or get along with them or talk to them at all, but I could not open a off-sale liquor store because my parents own 2, is that correct?
In this, if you're in the same class, that would be an accurate statement.
Okay. So, and that's kind of what I think Mr. Kavami was getting at is, and I understand where Mr. Weber's coming from in the fact that you don't want somebody owning all these and just paying people to have their name on it. But I also see families where, you know, they couldn't get into a business because mom and dad happen to own 2 already, which I don't necessarily think is right either.
I personally don't think there's an easy answer to that. I think, again, if we haven't ever come across that situation, maybe all of this time we're talking about it is a waste of time.
We don't normally do this during committee of the whole, but we have business owners in the audience. Would anybody have opinions?
Anybody have an opinion? Happy to listen. If nobody has an opinion, we'll move on.
I think you're in a really tough spot with this exact thing for everything that was said. You got children who do not associate with their parents, and you can do it.
Could you come to the microphone? Thank you.
Matt Wingen with Rhombus, guys. Yeah, I think on this particular one, you guys are in a really tough spot. I'm not exactly sure. Obviously, I have liquor licenses in Fargo as well, and I come up against this wording in different situations, and I don't think there's any easy way out of it for exactly what you're talking about. And even though the council doesn't want to have to make that decision of being, yes, you can have one, and no, you can't, that's why you guys were, elected in to do that, because you're going to eventually run into a situation where it's like, well, I can completely see that this is the parent, and you just, has multiple liquor licenses, but, right, I could do that. I could set up friends to do it for me, so whether it's children or whatnot. I don't think you're going to get to having a really good way of typing this up and putting it in there, because it's just tough. So I think in some situations you might just have to make that decision when somebody's applying and keep it as simple as possible. You can only have 2, and you can only have 2 in this class. That's what it is, and nobody else can have any other, you can't have any other interests in other ones, sort of a thing. I mean, you went so far as, I think, to say employees of it couldn't be involved with it. I mean, you got like Happy Harry's is an ESOP. It's an employee-owned thing, and there's liquor licenses, and it's just, you're really starting to restrict people from opening up businesses, so.
And that was in the existing ordinance.
Yeah.
Just.
I think part of kind of the problems we're hinting at are somewhat taken care of by the percent ownership, because most likely you would have a percent ownership if you were trying to get friends to open different franchises or something like that. So I think that having that in there kind of takes care of at least some of the issues with that, because you would presumably think there would be some sort of agreement, even with spouses and kids and parents. If you were opening several franchises of a business, you would think there would be some sort of, I guess, business agreement in some capacity that we would probably catch with that 1% as well.
Mr. Weber?
We want to stay out of the business of picking winners and losers. On the other hand, we have an obligation to try to create an even playing field. I think the intention here is to establish an even playing field. Is there a 100% foolproof way of doing that? No. But we want the tools at our disposal. We can always bend our own rules if there's a compelling case. But we want the tools in place when we need to use them. That would be my sense.
And I want to make sure it's clear. The intent behind this change was not to make the change, but to clarify as to how it was being utilized, the ordinance was being utilized, and try to come up with what meant by an immediate family.
Yeah. Yes, Ms. Mock.
With the employee issue, that seems a little bit more restrictive, that each license is counted as a license for each employee of a retail license holder. Is that something that we could consider taking back out? It was in the existing code, and so you clarified what
Absolutely.
we had, so that's either something we could keep or take back out.
Absolutely. The way the ordinance reads right now, it says, "Nor shall any retail license be issued or granted to any person who is employed in any capacity in connection with any two or more other licensed liquor establishments."
Do you see that being an issue with having ESOPs and things like that, where an employee is an employee owner?
And I don't know who is, in that sense, I don't know who is the license holder. I don't know if the ESOP is the license, I don't know that.
So that might be dependent on
Potentially,
who holds it,
and
if
if
it's the ESOP or
if
not.
everybody's an employee, and I suppose it could be an issue in that regard, that everybody that is part of the ESOP is deemed to be counted as having a license, a Class 2 license.
Interesting. Any other comments? Well, between now and when we next see this, we should all think about this and have our ducks in a row. Moving on.
All right.
Discuss it?
Yeah, the next one is 210221, just hours of operation. There was a state statute that was passed effective August 1st that allows for premises to sell starting at 8 a.m. on Sundays. That's really the primary change. So this change parrots the century code that was passed. The next, I didn't make any particular change to this, but it was, because I wasn't sure exactly where the council members may be. I didn't want to spend a lot of time in trying to develop something, but this is the delivery of alcoholic beverages. Right now, it's prohibited, except that we've got 3 emergency orders that are outstanding that will expire at the end of June, when our emergency status expires. And I just want to go through it with each of you so you kind of get an understanding of what those emergency orders are. They were all issued on June 13th of 2020. The first one was for Class 4 restaurants only. It was only for beer and wine takeout. Sealed bottles of beer and wine, there was a 64-ounce limit, but there was no delivery on that particular emergency order. The next one was 2020-8.2. It allowed for beer and wine delivery, and it was for Classes 1, which is full on and off sale, Class 3, which is beer and wine, Class 4, which are restaurants, and then the 16, which is a brewery tap room. There was no third-party delivery. There were hours of limitation between 11 a.m. and 11 p.m., and there were limitations on the amount of 64 ounces. And then the last one was 2020-12.2. This is for classes 1 and 4 only. It allowed for mixed alcohol drinks, beer and wine for takeout and delivery, so it expanded it. Similar, employees had to deliver. There was no third-party delivery. The hours were from 11 a.m. to 11 p.m., and then there was limitations on size, which was a little larger, basically a 12-pack of beer, 1.5 liters of wine, 64 ounces of a mixed drink, or 1 liter of alcohol was permitted under the emergency orders. And just to kind of give you some background, I did some research on delivery and whether it's allowable. I found an old AG's opinion authored by Nick Spaeth back in 1990. He concluded under North Dakota law, which is important, that delivery of beer was not authorized under North Dakota law. But we're a home rule city, and there's a statute that allows not just home rule cities, but all cities to regulate alcohol sales. And there are a number of Attorney General's opinions that talk about the breadth of the authority of a home rule city with respect to alcohol regulation is even broader. So based upon that, I believe you could, if you wanted to, adopt an ordinance that would allow for delivery. The other reason I say that is Minot does, and hopefully you got a copy of the Minot ordinance, does allow for delivery, and it's not just for, each one of the emergency orders dealt with, it had to be with a meal. It couldn't just be delivery. Minot doesn't have that type of qualification. Their qualification is it can't be by a third party, and this must have been adopted several years ago because they only make reference to taxi cabs. But there are requirements that if you're going to deliver, you got to have stickers on the outside of the car to know who it's coming from, and there's documentation that's required with respect to the delivery. I've reached out to the Minot City Attorney and haven't been able to connect up with her up to this point. But if there's any concern about that, it would seem to me that if there is concern about this being allowable under North Dakota law, then those emergency orders would have been problematic as well. And there hasn't been any, as I understand, any issues. You could ask for an AG's opinion if you felt the need to do that. Some of the things I put in some comments about if you were going to consider this, some of the criteria that you might want to include within a delivery type of ordinance. And the way I'd envision it, I think the last comment is basically whatever you could drink if you were going to have that meal on site. That type of limitation. Again, these are just food for thought. It's not something you guys will have to give me direction. But those are some of the things that come to mind anyways.
Any questions? Mr. Weber?
A comment rather than a question. Thanks for this information, and it's mildly intriguing, but as someone who worked and lobbied for the delivery of beverages during the pandemic, it was always my intention that that was only under an emergency situation during the context of the pandemic, and that as soon as those emergency orders were terminated, lifted, that we would go back to where we had been, that we would not be continuing the delivery of beverages after the pandemic. That was my intention all along. I'm willing to have further discussion, but at this point, that would be my call.
Other comments? Mr. Weigel?
I think it'd be interesting hear what business owners have to say. If it's something that's helped their business or it's something that they like, I think like any city code or any emergency order, we might have ideas that come out of some of these things that might benefit some of the business, especially local businesses here in Grand Forks.
Yeah, Mr. Weber?
My belief, my understanding is that businesses absolutely benefited from this. There were also other businesses who would suffer from that ongoing. But they agreed to this under the context of the pandemic, recognizing the extraordinary situation. And they came along with the understanding that this would be ended after the pandemic.
Okay, you want me to go? I have been, since the beginning of the pandemic, telling people that I believe that delivery of alcohol was allowed specifically to help the businesses that were struggling. I believe it did what it was supposed to do. I'm truly on the fence on this issue. I've been pretty vocal about the fact that I spoke to several Class 2 liquor license holders, gave them my word that I would not vote to support this after the emergency orders pass. That being said, I spoke to a pretty prominent Class 2 liquor license holder that essentially said the same thing as what Mr. Gosted has put in writing. As long as you don't open it up to Class 2, as long as the establishments are local, they're not pop-up restaurants that are serving delivery, you're not allowing the Ubers of the world to deliver alcohol, you actually have to serve it or sell it with a meal, and it has to be sold by, an established liquor license holder in town. They're relatively receptive simply because, as the discussion went, and perhaps some of the people in the audience would be able to fill me in. He didn't think that the bars and restaurants were going to want to keep doing it anyway. Perhaps some might, but the majority probably wouldn't, simply because you have to staff it, you have to insure it, you have to manage it, and just finding employees as it is today is hard enough, let alone managing additional. So I think if you're already in the business of delivering food, it's easier if you're not doing a significant amount of food delivery. I mean, I can see buying a six-pack of beer with pizza, right? It's easy. And, and perhaps if you're ordering from one of the downtown establishments, you might order a steak and have them bring you a bottle of wine. But other than that, I guess, and again, I'm still not sold on this, but I just don't see a whole lot of people, because most people that are going to pay for that are going to want to go out and have it in a nice restaurant anyway. They're not going to want it necessarily delivered. So I don't know. I'm, like everyone else, probably interested in hearing what Matt, if you want to step back up and give us your opinion again, that'd be great. And then Matt, you step up and give us your opinion as well. And any other Matt that's here can jump in.
There's another one. Once again, Matt Windjam with Rhombus Guys and Rhombus Guys Brewing. So actually I work, my businesses have some play on both sides of this when you're talking about Class 2, right? Because I have relationships with them because I'm distributing my beer too, right? So I don't want them to be upset and that sort of thing. But and you asked about has it helped us? And sure, absolutely. It's helped us. It hasn't been a enormous boom, right? But the truth of the matter is, sales still aren't back to where they were pre-pandemic. And so you're saying if this was something that was going to be used to continue to help us through the hardships, when are we ever even going to know when those are done? And I guess I would say it has helped us as a business. And furthermore, people's habits have changed. And so as we look at our business in terms of carryout and delivery, in terms of a percentage of overall revenue, it's about doubled in what it does for our business. And so what I'm saying is fewer people are going out to eat, but they may still be taking a pizza or some other food for carryout or for delivery. And as a restaurant owner, what I want those people to be able to do is still, buy the beer that we produce around the corner or something else and still get the full experience that they would otherwise have gotten when they come in. And so it helps us. Obviously, I would be in favor of it, even though, like I said, we do have relationships on both sides of this coin. What I would hope it would do, to be honest, would be like, oh yeah, you can get a 6-pack of Brown Biscay's beer with your pizza, and if you like it, go pick some up at your local package store, right? That sort of a thing. Or where else can I find this in town? If it gets, say, a lot of our deliveries, right, are going to be going to, just by the nature of the business, they go to hotels. And so if somebody's in town, they get something delivered. Oh, if you guys tried this, oh, I really like this, maybe I'll go pick some more up before I leave town. So hopefully it just generates more business for everybody, and that it doesn't, in fact, hurt people. As far as I know, in the conversations that I've had with people here in the city and with my businesses as well, I have not experienced any issues with it. I haven't heard any from the city as well, or from the police department or anybody along those lines. So we'd be in favor of it, and I guess it's helped us out to some degree, and that's where we'd be on it.
Mr. Windham, can I ask you a question about your business?
Yeah.
When you're selling beer for delivery, are you
Yeah.
selling it at retail the same you would sell it in your store, or are you selling it at lower price like you might be able to get it at a Class 2 liquor license holder?
Yeah, it's a great question. So, typically it would be in between is the answer. I'm not gonna, if I sell them a 6-pack, it's not gonna be the same as if you're in our store and you're purchasing your table purchases 6 pints of beer. But it is still at a markup because I'm purchasing it at my pizza place through a distributor. So it's already been marked up from the brewery coming back to me. And now, so I don't really have the opportunity to sell it at a discounted rate.
Yeah.
So I sell it, and I sell it at a price that I believe to be fair for everybody involved.
Great. Okay. Thank you for that. Appreciate that insight. Anybody have any questions for Mr. Windham? Okay. Mr. Wallowak, I am interested in hearing your opinion.
I haven't delivered any beer to your house.
No?
Matt Wallowak, Ground Round. I mirror most of Mr. Windham's comments. It did help our business during the pandemic. We are far from back to normal as far as people dining out. Our delivery and carry-out business is carrying the majority of our business still. And I've talked to other Class 2 people about this as well. And I guess for us, we would be interested in carrying it forward more when the hotels do fill up. Back before the pandemic, if I had $1 for every business guy that wanted to order delivery to the hotel, and if he could get a 6-pack with his burger, I could probably retire. No, I couldn't. But it would be a nice add-on. It's not going to make or break us, but I think it doesn't hurt either. We don't get the volume discount that a Class 2 place can probably buy Rambus's beer, but so I'm not able to sell it at a price where it would make it beneficial for them to go through me versus a Class 2 establishment by any means. So I guess that's all I have to say.
But you'd offer a convenience.
Convenience, yes,
Convenience.
definitely.
Certainly, which is worth something.
I don't, even during the pandemic, I mean, there was definitely some houses and whatnot that we delivered to, but that has decreased. I primarily see it for the out-of-town business guy that doesn't want to go out that night, or for whatever reason has to work in his hotel room and doesn't want to go out and maybe he flew in, doesn't have a car, various reasons, but I just see it as a convenience and a nice add-on occasionally to an order.
Thank you.
Our drivers go through the alcohol training. It's no different really than serving anyone at a table. And they card the individual, and it's their responsibility, which obviously falls back on the license holder, but I'm willing to take the risk.
Thank you, which certainly, Mr. Gosted, if this went forward, we would want to make sure that anyone delivering would have to have passed that.
I think they do. That was part of it.
Yeah, you're right, it's part of the emergency orders, but we want to adopt that, and
Right.
there is language in the Minot ordinance, I'd use that a little bit, and then, reference in all the other training requirements that already exist within the ordinance, within the delivery provision.
Thank you. Does anyone have any questions for Mr. Walwack? Thank you.
Thank you.
Thank you. Anyone else in the audience have any other thoughts that, beyond what we've already heard today? Thank you. Okay. Great, so I'm not sure exactly where that leaves us. Mr. Weber, has your opinion changed at all? You said you'd be open. Again, I'm on the fence, but I know I'm only one person. I wouldn't want to ask Mr. Gosted to do a whole bunch of work if there isn't at least consensus to read some language and then have a debate on it. Is that worth?
Yeah, in some ways, this is a living document. We can change it at any time. This is important information, both from Mr. Gaustad and from the business owners, and from you, too,
Yeah,
President.
well, and I think between now and when this comes back,
Right.
and certainly before final adoption, getting the word out to other liquor license holders that we're talking about this, hopefully it'll be reported in the newspaper. And I'm interested in hearing from people that have an opinion. I know I have my opinion, but mine isn't the one that necessarily matters in this situation, which is why I want to know how other people feel about it. And I really appreciate all the Matts showing up today to give us their opinions, so.
Very good, thank you.
So, Mr. Gosted, I guess in general, probably move forward with drafting some language, assuming you're not going to put in too much. Minot's language is relatively short and sweet, so I would hope that ours could be as well.
I like to be thorough.
Yeah, I know you do.
It'll take some time.
Sure.
Which is not a problem. I've committed to do that, and I'll use the items that I've listed in the comment to this, where it talks about delivery must be with the meal prepared on site, not by a third party, taxi or Uber type of method. The other thing that somebody brought to my attention is there should be sufficient seating from those premises that are delivering, so you don't just have somebody doing the pizza and they have no dining facilities at all. So some seating capacity and then some percentage of in-store eating seemed to make some sense. That was a thought that somebody brought to my attention that I thought was a good one. And again, trying to make it in drafting it so that the language would be such that it's as if you're sitting in the premises and having the alcohol, and that would be the quantity deliverable.
Yeah, Mr. Weber.
After months of being in the COVID crosshairs, I'm hesitant to ask, but I'd also be curious about public health's opinion about this. Yeah.
Is anyone from here, from Public Health? And if you're not prepared to speak to it today, that's okay. You can come and speak to it the next time this comes up. Ms. Swanson, thanks for being here this evening.
President Sandy, members of the council, I didn't come prepared to offer extensive remarks this evening, but there is an advocacy group concerned about alcohol licensing and prevention efforts in the community, and I think their voices should be heard. I have two concerns about the document overall that I can share with Mr. Gosted. They relate to one section of the delivery where I think the language needs to be updated so that it's not pejorative, and it's on page 37 at the very top, delivery to certain persons prohibited. And then the other section is on distillery licenses. I do recall that there was some activity around distillery licensing in Grand Forks because I requested that the sample sizes be reduced. So I'll go back and look for my language on that particular section about distillery and sampling, because I just checked the Century Code. It doesn't limit the number of ounces that can be offered to an individual in the Century Code. So the city code that might be relative to that should be referenced. Those are the only two comments I have at this time, but I will certainly inform the Substance Abuse Prevention Coalition that this conversation is happening at the council level. Thank you.
Thank you, Ms. Swanson. I agree with her. Calling people habitual drunkards probably isn't necessary. Right. Yeah. I don't know how that would even make it into city code at some point in the past.
I think that's in state law.
I
think
don't,
I've
I
read
don't
that
know how
somewhere
it
in the
got in
state
there.
law.
Really?
Century code.
It's
Yep.
there.
That's amazing.
It was not one, it wasn't an ordinance that I was drilling down on.
Sure. Any other comments related to 21-0224 on delivery? Okay. Thank you, good discussion. Mr. Gosted?
All right, the last change is at 210228, and this
Page
deals
38.
with, on page 38 through, really 41, it deals with when those that are minors can be on the premises. And so what I've done is, because of the class 4 being fairly detailed as to a restaurant, they are deemed to be a restaurant for purposes of somebody under 21. I've then added a subsection 2 that is for class 3, 5, 7, 8, 8.2, 8.3, and 16. Class 3 is the beer and wine, 5 is hotels, 7 is golf course, 8 is the airport, 8.2 is Alaris, 8.3 is the Engelstead, 16 is the brewery tap room, and 17 would be the satellite, the new satellite for manufacturing distilleries. And again, I'm referencing in that they'd have to be a restaurant as defined under licensing for restaurants. And this is then also includes the full course meals of steak, fish, but then I've added language that talks about you can have prepackaged meals for those particular classes. The limiting factor with respect to a restaurant in that capacity and having somebody under 21 remain on the premises is then found under new subsection B, which talks about having to have your gross sales of food being at least equivalent to alcohol sales. So even though I'm a restaurant, right, and I'm serving these type of food, if I don't meet that threshold, that percentage threshold, then minors can't remain on the premises. And when I'm talking remain on the premises as patrons. Okay? The next change this is a change that was a result of state law that was adopted. And it talked about at the discretion of a owner of a licensed premises, somebody under 21 can remain on the premises if they're accompanied by a parent or a guardian, is seated or within 3 feet, is not seated within 3 feet of the bar counter, and does not enter and remain after 10 p.m. You'll notice that there is no requirement with respect to the percent of alcohol sales versus meals under the state statute that was adopted. So this language is coming directly out of that state law change. The next item, and this is, again, I didn't make any change on this, and this is an issue that was brought to my attention about certain Class 1 establishments being unable to have enough workers that are under 21 and being able to work and stay on the premises to work. Because we have not identified, the use of the word restaurant appears throughout within this ordinance. Class 1 is not identified as a class that would be within the restaurant component. And so if you're going to allow for somebody to work in a Class 1 as a waiter, busboy, busgirl, or waitress, you'd have to include Class 1 within the definition of a restaurant. And that would then bleed over into the new subsection C that talks about any person under 21 years of age when employed by a restaurant, licensed to sell alcoholic beverages as a food waiter, food waitress, busboy, or busgirl, may be employed as long as they're not engaged in the sale of alcohol. I did look at the Century Code, and the Century Code has the same language to it. It doesn't, there's a comma between, they differentiate between a restaurant that has the 50-50 food and sales, those are patrons. And then it has a comma, or be employed as a busboy, busgirl, waiter, or waitress, but doesn't then tie in that 50-50 sale parameter. So you can work there, but you can't eat there as a patron. But we don't allow that because we have it identified as Class 1 as being a type of establishment that could have those type of employees work.
Can you give us just an example?
Brick and Barley would be a perfect example.
Perfect, yes.
Yep,
Okay.
they're Class
1.
Class 1.
21 and over.
They have food, they fit within the definition of a restaurant as I've now redefined it, but because we haven't allowed them under our ordinance to have underage employees in those limited capacities now, just as a waiter, waitress, busboy, I suppose as a cook, right, would probably be okay. But you couldn't be, let's say they had a separate off-sale facility. They wouldn't be stacking beer in the refrigerator in that off sale. That's not, you're not in the capacity as a busboy at that point. You're doing something different.
Any thoughts regarding having people under age 21 working in a retail bar establishment, 21 and older? Anybody have any thoughts?
And just as you're contemplating, I did have some limitations, things for you to consider. You know, how long the minimum age, how long they can work, things like that, that you could consider as well if you're going to make this type of change.
Mr. Gosted, have businesses been asking for this?
Not to me, just as I understand it, they're having difficulty finding employees.
I think younger people in general aren't working as much as they used to. Anybody have any, I don't know, Mr. Cavani?
Yeah, I would support under the age of 21 working, as long as they're not in the sales of alcohol, right? I think that makes sense. I think that's what I've experienced
If
in
you're
other
a
parts of the
waiter or
country.
a waitress, you would be selling it, right? So no.
They would
Mr.
not,
Gosted says
no, they would not be able to do that. They may be able to take the order, but they'd have to have somebody else deliver that alcohol. They couldn't dispense it, they couldn't, and they'd be able to, you know, write up the ticket and get the money, but they would not be able to actually deliver.
Is this how does this differ, what we're talking about, how does it differ from how it's done in Minnesota?
That I don't know. I don't know.
I believe Minnesota allows it.
I believe Minnesota allows it, but it's 19, is it 19 years old and older? I'm not 100% sure.
Yeah.
But I believe that to some degree, I know that people under the age 21 can take your order in a bar, but I don't know if they can carry it to you.
You can do that under North Dakota law. We just haven't allowed for it in the city of Grand Forks because you haven't identified Class 1 license holders as being allowed to do this type of activity.
Are there any yes, Ms. Muck?
I mean, considering there are limitations and it's under the direction of the bar owner, I think it's essentially just allowing for a slightly bigger employment pool, you know, and they don't have to employ younger, so it's still up to them if they don't want to take advantage of that.
Mr. Weigel, I'm interested in your opinion. Do you think this would promote alcohol to people under 21?
I think there's potential for everything.
Yeah.
I'm caught on the fence because I see the opportunity for businesses to draw from a larger applicant pool. But I do also see the other side, where somebody could make the argument that, you're exposing them to alcohol at a much younger age. But I think you could make that argument for anything, whether that be the Alair Center, whether that be at the Ralph, or heck, maybe even at home.
I suppose you could be working at, I don't know, any number of the restaurants, in the Matt's restaurants.
Yeah.
And can be taking orders for alcohol, right? And, yeah, Mr. Walwack, yes? Ground round, people under 21 can work as waiters and waitresses,
So
correct?
at Class 4, at 19, they're allowed to sell, but they have to be 21 to pour. So they're already selling it in our establishments right now at 19, and Minnesota is 18.
18. Okay, thank you. I'm glad you're here. So I guess in general, it probably is what it is, right? Okay. Any other comments? Okay. Of course, I'm looking forward to hearing from the Department of Health on that topic as well next time this comes around. And then,
Should I take it back that you want me to try to draft something
I
up?
think so,
Okay.
probably, yeah.
Those are all the changes. I think we've gone through all the other change with respect to minors was that special events. It was just a function of the special events where it was, it's on page 40 to 41, to be consistent with the special events license and the change in the state law. And I think we've already talked about that. Those are all the changes that I had. I'd be happy to listen to any other.
Mr. Gonstead, where were we talking about the gaming?
Oh, that was it's under the Class 4. That would be at pages 9, or page 9 of the document that was sent out.
I just wanted to circle back quick. I think even I said that I think the language was probably fine. I just wanted to make sure that there weren't any other, because I know this had some discussion previously, and I know that there were others that are here that are interested in it, but also probably others that didn't know that this was coming on today. So again, hopefully this item will hit the radar for the newspaper, and ultimately so we can get additional input from Class 1 license holders, for example, that might have a different opinion, and just so that we're all educated on it. Otherwise, any other, anything? Yes, Ms. Mock?
Yeah, I have a little concern about the gaming still. I'm hoping maybe we can hear from some other people. I guess part of my concern is if some of the point of opening the gaming to Class 4 is to try to open opportunities to other groups, I'm somewhat afraid that that might not happen, since if you're already doing gaming in Class 1 establishments, it seems like a really easy thing to go into Class 4 establishments. So I'm not really sure if that would accomplish that part. So that's one I'm definitely on the fence about still.
Ms. Weigel?
Mr. Gosted, I can't recall, is there a limit to how many gaming sites one nonprofit or whatnot can have within the city of Grand Forks?
I don't have that committed, Mayor. I don't know if there is or is not. I don't know off the top of my head.
Yeah.
President Sandy, Councilman Weigel, the limit is 10.
10. Doesn't seem like much of a limit.
Right, and so maybe, I know we've talked a little bit about, you can only have two of a specific class of license. Maybe we look at the gaming and say, if we're only allowing two for that, should we limit the amount of gaming operations that one nonprofit can have? Because if we're not interested in expanding this for other people to get involved, then should we be looking at it at the other side saying, well, maybe you can only have 5 to open up the playing field for other nonprofits that could use funding as well. So I think it's an issue that we should address, but I think there's 2 ways that you could address it.
There aren't any organizations that have 10. Are there any that have 5?
President Sandry, committee members, right now there are 2 organizations that each have 8 sites, and then we've got 1 organization with 3 sites, 2 organizations with 2 sites, and 3 organizations with 1 site. We do have 1 organization that used to have a site and currently doesn't have one because there isn't one available.
Yeah, Ms. Mock.
Do we know what the interest level is? You mentioned one that would like a site that doesn't have a site. Do we know what the interest level is on those that have multiple, if they have kind of reduced because it's been limited, or they're interested in expanding?
We haven't had anyone contact our office and say that they, even the one that currently doesn't have a site is Special Olympics. I've not heard from them that they're actively seeking a site, so they may have changed. We have seen some downsize, which has opened up for some of the other organizations to add. Some of them have just decided that they don't need more than 1 to support what they want to do. And that is why a couple of years ago, the organizations came and asked council to increase the number of sites allowed from 7 to 10, because they were capped and businesses weren't able to find someone to come in and serve them, because some of the ones that didn't have as many as allowed didn't want to open any more sites. So it's kind of a odd situation that I think might vary during the time, depending on what the wishes of the organizations and the business community are. It was just, I believe it was like 2 years ago that we increased that limit, and since then, I believe both Listen and DHI may have added a couple of sites, but not, they still have room before they reach their cap.
Mr. Weigel?
Was that before the time that electronic pull tabs became popular? Because I feel like we could expand it, because you're probably looking at more blackjack / pig wheel or something along those lines. But I think since electronic pull tabs have come out, that I think there's probably more demand for nonprofits to get involved. And I think we have people from those organizations here tonight that are interested in getting involved, but there's no availability. And I think the conversation would probably spark to more nonprofits getting involved.
Well, I think when I moved back to Grand Forks, whatever it is, 15 years ago, and Mayor Brown appointed me to Convention and Visitors Bureau, they had a site at Charlie Brown's. I spent more time, in my tenure on the board of CVB, I spent more time dealing with gaming issues that they had than I did actually providing any help to the Convention and Visitors Bureau trying to attract people to Grand Forks, which is why ultimately we got out of the business of gaming, because I don't think it's HR nightmare. I mean, you name all the reasons why you wouldn't want to do it, and I know there are other organizations that do it very well because they run it like a business. It's very professionally done. They have the staff, they have the infrastructure, they deal with it, and it does really well. I think you have to go into it with, if you're going to be running blackjack and pig wheel and you're having that kind of cash trading hands and those sorts of things, you have to be set up for it and prepared for all the downside. But now, as you're leading to, Mr. Weigel, throwing a bunch of machines and showing up daily to pull the money out of it seems pretty simple. and a real good opportunity or an easy opportunity for not-for-profits to actually generate some revenue without having the high overhead and all the risks that come with having a blackjack table, for example. So I don't know what the Class 4, again, whether Matt and Matt want to have it, but I don't know if they want to be dealing blackjack or if they just want to have the electronic pull tabs. That's up to them and their business and what they'd want, but certainly I would have to think that BMX, for example, Children's Museum, you name the not-for-profit. Heck, maybe an aviation foundation might want to get into it and put in the infrastructure to support whatever their not-for-profit is.
President Sandy, I'll
Yes,
throw
sir.
you a curveball. I think there's a third Matt in the crowd that could maybe speak on it, or Mr. Lucky, so not to confuse Matt 1 and 2, but we'll bring up Matt number 3.
Members of the council, I'm also Matt. Matt's maybe. I'm the hockey director for Grand Forks Youth Hockey. Thanks for taking the time to discuss this. I'll speak on the matter as it relates directly to us, but I think other nonprofits, as you guys are talking about as well, may have an interest in doing this as well. Like many other youth sports associations across the state, we're continually looking for ways to improve our services, the things that we can offer to our youth, while at the same time doing our best to keep the cost to a minimum to participate in our sport. As you guys might know, hockey is an expensive sport to play. The cost of it by itself, the equipment, the time, the travel, it's an expensive sport. So our interest in charitable gaming came as we compared how other associations across the state of North Dakota, as well as throughout Minnesota, have found ways to operate and raise capital without asking for more from their members. So that was our interest in getting in the charitable gaming side of things. As a nonprofit organization, we have been approved for a state gaming license for the purpose of charitable gaming. But as you guys have touched on, we don't have a spot. We can't go in anywhere. The Class 1 establishments that have gaming or that are allowed to have gaming already have their needs met by other organizations such as ourselves, so we're at a standstill. We feel as though by allowing establishments with Class 4 liquor license to designate an area for gaming, we believe that it'll help the businesses, but it'll also help organizations like ourselves, and it would help support causes throughout the city, not just youth hockey, but any other charitable organization that is interested in doing it to raise capital. I think it'd be a beneficial thing. I think it's also important to point out that establishments with Class 5 liquor licenses within the city of Grand Forks already have, with minors on premises, already have the ability to do what is being proposed here, places like the hotel. So this isn't out of the bounds of what's already being done locally. I will also mention that our kids play games and participate in tournaments in communities like West Fargo, Williston, and Minot, where this model is already in place and successful. Many times following a game, for example, parents, players, and coaches will go out to eat in an establishment that has gaming on site. And the only reason I would point this out would just to suggest that it's not unique or outside of the lines of what's being done across our state already. Our association is growing in the way we think about the development of our youth, but also in numbers. In the very near future, we're going to have a discussion about facilities and growing our program, which is an exciting thing, an exciting challenge, but we also want to be in a position to financially contribute to some of those things, as well as offer better services for our kids and our athletes along the way. So on the nonprofit side, from our perspective, that's how we view what's being discussed right now.
Thank you, Mr. Smaby. Appreciate you coming tonight.
President Sandy?
Yes.
If you
first.
like, what we can do is take the feedback from tonight, work with Mr. Gosted. This will come back on June 7th. We can get a communication out to all affected businesses, so they will be aware of that discussion. We do have a week in between here, so it gives a little more time before this comes back on June 7th.
Thank you. So, Mr. Gosted, just adding on to what Mr. Smady said related to hotels. Hotels, right now, some of them can have gaming and some of them cannot, correct?
Yeah, I'm just pulling up the gaming statutes.
Class 5.1, hotel limited service wine and beer specifically says no gaming shall be allowed on premises. I'm not sure why that is. And I'm not trying to put you on the spot, but under
5.1.
hotel alcoholic beverages, under 5 doesn't say, again, I'm just skimming. I don't see it anywhere where it says you can't have gaming, but I know that there are full-service hotels that have gaming in town, and I don't know if that's because they have a different liquor license than the actual hotel license, or what. But what I do see is under 5.1, number 10, it specifically says no gaming shall be allowed. I'm not sure what an example of that, is that a Holiday Inn Express?
That, because 5.1 is for limited service of wine and beer.
Right.
But you don't have the same language in Class 5 about no gaming. You pointed out seems like an anomaly between the two.
It seems like an inconsistency. Either way, if we're going to allow gaming in Class 4 restaurants, is there any reason why in a hotel that has a restaurant that we wouldn't allow gaming? I don't, just food for thought. Perhaps you can look into why it's written this way and provide some feedback.
Don't have any issue with that. I guess it seems to me that if it's not in there, that precludes it. It seems like if you've got the state license and you've got the site authorization, the gaming should be allowed at that level.
Okay.
That would be but I can certainly take a look and see if there's other classes that would be affected by the no gaming provision. And if we're going to do, if I'm hearing you right, if you're going to do Class 4, and there's a consistently, for example, the hotel example you've given, should we open gaming up to Class 4 to make that clear too, or not?
Yeah. Well, and I think if we were going to say that a hotel can, I think they would have to follow the same, you have to have a designated spot that's 21 and over, and that same, you don't just put it out in the lobby, the Stay Bridge.
And that's
wherever.
precisely what I was thinking of,
Right.
President Sandy, is that if you're going to have these rules for Class 4, have a consistent rule with a similar type of establishment with the designated area that you just talked
Right.
about.
Okay. Fine. Mr. Weber?
A couple issues that haven't been addressed at all. All of the classes, currently the city can issue an unlimited number of all licenses, all classes of license. I believe that there are other communities that limit it in different ways by population or whatever that might be. How much work would it be to bring back some options on that front? And also, we haven't discussed anything about the charges per license. And I think that's as important as anything to our business owners, yeah?
Yeah, and those are established by council by resolution, I think, on an annual basis.
On an
That's not
annual
necess-
basis?
Yes, that's not necessarily within the ordinance itself. The council establishes that. As far as the limitation on the number, I've seen it both ways. That becomes a very valuable asset. if you-
I believe
if
the
you
city of
limit
Grand
the-
Forks used to have limitations on its liquor licenses and chose to eliminate those so that the liquor licenses don't become commodity.
Okay, well, that's a good answer to that question. And once a year, we set the rate.
Every budget.
Yes. President Sandy,
part of the budget
Councilman member.
process?
Yes, those actually get set, if you remember when we bring the budget forward, you're also approving an attached fee list. We haven't changed those fees for many years, but it gets approved with that fee list. The liquor fees are included in there. So that'll come forward to you again this year.
I'll pay closer attention, thanks.
Yep. Okay. Good discussion tonight. Any other comments? Yes, Ms. Mock?
Mr. Costa, I think it was for baseball, did we change our ordinance to allow them to sell in the can? Is
We
that
did.
what we did?
We
And
did.
was that a permanent change? Is that?
Yes.
Okay.
And
So we don't need to address that in
no,
these
that's already,
changes?
you've already modified that, and I would bet that I forgot to include that within this, but that has been changed.
But
so
that
they can
was
sell
changed
cans.
permanently,
Yes.
so we don't need to worry
Yes.
about it? Okay.
And I believe that
Good
comes
catch.
forward for second reading
second.
on June 7th.
Yeah, good catch. Good. Anything else? Okay. Unless anyone in the audience has something really pertinent to add, thank you all for being here this evening. Appreciate it. And thank you for all the work, Mr. Gostet. Really informative. Moving right along. Item 2.5, special assessment policies. Mr. Walker would like us to adopt some new policies. Mr. Walker was kind enough to send me the red line version this afternoon that I forwarded out to people. I don't know if Mr. Walker will let you give your spiel, but I don't know if, I'm hoping everyone had a chance to review that. Mr. Walker, good evening.
Good evening. So for numerous years, the city has had a policy regarding special assessment, how to create the district and how the commission would assign benefits for a project. And so back in 2015, the North Dakota State Legislature passed a bill requiring cities of greater than 10,000 in population to have a written policy, and that policy be adopted by the governing agency as well as the Special Assessment Commission. And so that was done back in 2015 by both the council and the Special Assessment Commission. And since that time, no changes have really been made to the policy. It wasn't until recently that we discovered that there was something missing from the policy, and that was relative to assessment of maintenance of drainage swales, which is the next item on your agenda. So we went and we visited with the commission and decided to add that to the policy. We also looked at the policy to see what other changes should be made to it. And the other thing of significance was when a bike path is adjacent to a corner lot, the front of the parcel was assessed for an equivalent of a 5-foot sidewalk, but the side wasn't. So we changed the policy, I should say the commission changed the policy so that a corner lot would be assessed similarly to having a sidewalk, whether it would be on the front or the side. So there was a few other miscellaneous changes that was made to the policy. We discussed the policy with the Special Assessment Commission, the current policy that you have before you, and it was adopted by them back at their May 10th meeting. Because the original policy was adopted by council, we're back here to ask you to adopt the updated policy as well. And once that is done, we will publish it on the web and distribute it to those people who would normally use it. So our recommendation would be to adopt the updated special assessment district boundaries and benefits determination, general policies and guidelines.
Thank you, Mr. Walker. Out of morbid curiosity, if we don't adopt this policy, what happens to the next item?
We would probably hold it.
I see. Any thoughts, comments? Mr. Weigel? Moves approval. Is there a second by
Second.
Mock? Great. All those in favor signify by saying aye.
Aye.
Opposed, same sign. Motion carries unanimously. Thank you. Item 2.6, then we'll create the special assessment district for project number 8096, District 569, swale improvement adjacent to Breezy Hills Cove. Mr. Walker?
So this project involves removal of buildup and obstructions in swales that are causing backup on, water to back up on upstream properties. We predominantly have swales only in the Sunbeam Addition area. That's the area between the river and Belmont Road and 47th Avenue and 40th Avenue South. So in that area, when the development was done, they used swales that would drain the street into a swale that was in the backyard, and sometimes there would be a pipe that would go underneath the street, and one swale would drain into the next swale. Eventually, it would drain into a storm sewer that parallels the levee and then into the Red River. The policy that the city has had is that individual homeowners are responsible to to clean that swale and to maintain it. There's a little bit of a buildup, they need to pull the material out. If there's leaves and that type of thing in the bottom of the swale that's obstructing the flow, they need to kind of rake that out. And so the policy has been that the property owners is to take care of those things. And in the past, it has worked relatively well. In other areas, the swales have been maintained by the property owner, even though the city may go out and stake it for them, that type of thing. Back in 2017, we started working with property owners in this area who were concerned about water backing up in various areas. We worked with the neighborhoods to try to encourage them to try to do the swale maintenance work themselves, but didn't have much luck. So in 2019, we had a public meeting where we invited a number of people from the neighborhood and indicated that if we couldn't get cooperation from the neighborhood to do it themselves, we would do a special assessment project. At that time, the majority of the people attending the meeting asked that they be allowed to do the work themselves. And so a timeline was established for them to do the work. And for the most part, I would say 80% of the properties have taken care of the drainage issues and reestablished the drainage. But there are about 20% of the properties that have not done that work as of yet. So the intent of this project would be is that we would go in and finish that last little section of swale cleaning work, hire a contractor to do the work, and then assess the cost of the work to those properties who haven't completed their swale cleaning work. So that is the intent of this project. So with that, our recommendation would be to approve the engineer's report, create a special assessment district, and direct the engineering department to prepare plans and specification and advertise for construction bids for this project.
Thank you, Mr. Walker. Mr. Weber, question?
Thank you, President Sandy. Nice to see you, sir.
Oh, thank you.
Currently, if a homeowner, property owner isn't mowing their lawn or shoveling their walks, and they've been given enough notice, we go in and do that. Could that type of ordinance change, could we include swale maintenance under that ordinance change? Would that be an easier way to go forward? Apparently not, because you've brought this forward.
Actually, that question was actually asked. We review that with the city attorney. As I understand it, the way that the city code is written is that's not permitted. So we went with this route of creating the district. If in the future you wish to handle that in that manner, I would suspect that an ordinance change could be made, but I'll let Mr. Gosted explain further.
Yeah, we did review, and I don't have, I didn't commit it to memory, but the way the ordinance is, and I'm working off memory now, right, is that it's the length of the grass, and you could impose some sanction, some penalty and fee for doing that, but I think what you're talking about is probably more than simply cutting the grass. You're getting rid of silt and things like that, you know, and it may be one of those things that it's not necessarily the landowner's problem that somebody else's silt is landing on their property, and there's more work than just cutting the grass.
Thanks, yeah.
Mr. Grasser, something to add?
If I could add to that too, I think some of the differences, if you're looking at, you know, we do something similar to removing snow on sidewalks and cutting grass. Those things are contained very specifically to that property. The swales usually are right on the property line, and it's hard to differentiate and say, okay, this particular property owner has that. So usually you're grabbing a couple of them, which kind of helps, I think, lead you into a district as opposed to an individual, I think, lot citation like that.
Right,
That all
but
makes sense. Thanks.
That's, when reading through this, I anticipated seeing the district being a house here, because it said that many of the property owners have been taking care of it. So how does it end up that we have 14 properties all contiguous that didn't maintain their swales, yet everyone else did? Was there an agreement among the neighborhood not to deal with it?
I'm going to say good luck on my part. But I think what happened is that you had neighbors that banded together and did the work. There's one area in here where you had a guy that knew how to run a mini excavator, and he went and got one, and he did several properties. And they banded together and it did the work as a group. I think you have a group of people here who just didn't band together. And we are very fortunate that it all is in one area, so we're going to be able to go in and, do this one area, and it's all contiguous.
All of these neighbors been informed? I mean, I know that there have been letters, I've seen that, but is it now very clear to them that we're going to do it?
So you are correct that there's been several letters that have been sent out to the property owners saying, you have this deadline. We've actually even extended the deadline. We've offered to meet with them personally if they wish. The intent now would be is to take this to the Special Assessment Commission after the district has been created to determine benefits. Thereafter, the Finance Department will send out a letter to each of the property owners stating, we're proposing the project and here's your estimated assessment range.
And so we're estimating 44,000 by 14 properties, 3,100 and change. Are we expecting that they're all going to be about the same? Or are there certain properties that are going to benefit more? Again, morbidly curious, because I'm trying to figure out how if we're saying that the silt comes from somewhere else and gets distributed here, and now all of a sudden I'm carrying the burden on this.
So the policy that we had in the previous agenda item indicated that the property owners that are adjacent to the swale would pay based on a linear footage. So if you have one property that has 50 feet and another one has 100 feet, well, the one with 50 is going to pay half as much. So the work is likely going to be similar from one end of the swale to the next. However, the policy also says if there's a large obstruction, such as a large tree or fence or something like that, that individual cost can be assessed to the property owner who has that obstruction.
I'm sorry, I've been dominating. Yes, Ms. Mock?
I guess my first question is probably easier, is it protestable if they get this large bill for this? Do they have the right to protest this, or are we considering it like some of our water projects where you can't protest?
So in the state of North Dakota, as I understand it, sewer and water projects are not protestable.
So this would not be.
This would not be
We'd be considering
protestable.
this in that vein. Okay. Because then my other question was, it reminds me somewhat of sidewalks where you technically have the right to do the sidewalk in front of your house, but we also hire somebody to go do sidewalks for the summer to get it done. So in this case, we're essentially saying we've offered them the chance to take care of this themselves. It hasn't gotten done. So now we're going to take care of it as the city and hire somebody.
That is correct. It is very similar to the sidewalk program.
Frankly speaking, if my storm sewer had an issue, the city wouldn't give me the opportunity to go and fix my own storm sewer. These people had an opportunity to save some money on their storm protection, and for one reason or another, they chose not to, and that's fine. That's certainly their prerogative. Maybe they just want it easy and have the city do it, so.
Yep.
And any other questions? Can builders still build with swales? Is that part of city code?
I don't know that it's prohibited. We would likely discourage it just because of the problems associated with it.
But it's got to be significantly less expensive than putting in the storm sewer.
It is, but a portion of your backyard is consumed by a drainage swale, and
perhaps you get a bigger yard because you're saving 15 grand on storm sewer, perhaps? Mr. Grasser?
Well, if I can, I think this area was somewhat unique. The original trigger was that the area was inside the, subject to flooding. It was in the FEMA flood zone, and so they needed to build that property. They needed to invest the money to pick this dirt up and build up the sites. In doing that, you leave a hole. Well, they got creative and made a swale out of it. Most areas of town I would tend to probably disagree that I think that the effort of moving all that dirt to actually create a swale similar to this is probably more expensive than just putting in a pipe.
Really?
To a lot of.
But if it's designed to hold water and could act as a holding pond as well?
That's what these people are objecting to. I mean, we had.
Because it's holding water.
A couple of hundred, yeah, that's the
Yeah.
problem, is it backs up, it holds water, so you aren't able to enjoy your backyard, you know, it's more, you got more insects and mosquitoes and different things going on there.
Okay.
If you go look on some of these, there's places where people want to be, you know, getting their garden and landscaping and things like that. They want to utilize the full effect of the backyard.
Right.
And if you've got a couple feet of standing water in there all the time, well, things don't grow very well.
Sure. Mr. Weber moves approval? Yes. Is there a second? Second by Kavami. Any other comments? Hearing none, all those in favor signify by saying aye. Aye. Opposed, same sign. Motion carries. Thank you, Mr. Walker, Mr. Grasser. Good discussion. Item, Mr. Grieco, good evening. Item 2.7, Plans and Specs, Project 8074, 2021 flashing school beacons.
Good evening, President Sandy and members of the committee. This project is using federal dollars from the Highway Safety Improvement Program. It's got about $630,000, and it's a 90-10 split, so 90% federal, 10% city. This project is intended to upgrade our school beacons and essentially make it so that we can program these things remotely. We can program them so that they are only flashing at the appropriate times when children are actually anticipated to be there, as well as school having pedestrian push buttons on those school beacons as well. Currently, we don't have all of those capabilities, and so this project will be taking care of that. In addition to that, this past year, 2020, we ended up using local funds on our electrical contract to install conduit and fiber to each of these locations so that they can be connected to our interconnect system, so it can be accessed from Public Works and otherwise remotely. It's anticipated that this project is going to be constructed in 2022, and with that, staff is recommending approval of plans and specs.
Any comments?
Move approval.
Moved by Kavami, second by Weigel. Any other comments? All those in favor signify by saying aye. Aye. Opposed, same sign. Motion carries. Mr. Weber abstains. 2.8, decision document, information only, project 8228, reconstruct North 4th Street from Demers to 1st Avenue North. Mr. Kranko.
This project is utilizing about $1.6 million of the Urban Grant Program federal funding. This project is for the reconstruction of North 4th Street from Demers Avenue to 1st Avenue North. This is going to be similar in line as to the 3rd Street project that's currently ongoing and the Demers Avenue reconstruct that happened a little while back. This project is currently in the environmental phase, and we are anticipating a public input meeting taking place here on June 10th from 4:30 to 6:30 p.m. It's going to be a hybrid meeting, so it's going to be held likely at CPS Engineering, who is our design engineering consultant for this project, as well as over Zoom. So that is going to be available. We'll end up having that posted. This is an information-only item. And at an upcoming committee of the whole meeting and city council meeting, we will be looking for action from city council to look at our available alternatives on this project and narrow it down hopefully to just one alternative. That way then we can save some costs on working through all the design alternatives. The current design alternatives out there is, and actually I'll click through this. Our first option is what we have on the screen right now. And this is a very standard reconstruction similar to what we have seen on 3rd and what we saw on Demers. We are maintaining our parallel parking. We have our decorative pavers, our decorative street lights, as well as the bump outs. The other alternative, which this was brought up in the Grand Forks, East Grand Forks MPO's downtown study or plan, which showed a buffered bike lane along 4th Street. This alternative is significantly more expensive, and it also would require the reconstruction of the intersection of Demers, as we would need to work that through that intersection, which we just reconstructed, and that bumps the cost of that alternative up by about $1 million. We're looking at this alternative as an option because it was identified in the MPO study. Staff will likely look to City Council to look at removing this alternative. Like I said, though, we are going to be holding a public input meeting on the 10th to hear from concerned individuals on this project and what their thoughts were. This is an information-only item, so I'm here to answer any questions you may have.
Thank you, Mr. Karinko.
Great information, thank you.
Kavami, yeah, great information. After all the work we did to get the bump outs on the other cross streets, in my opinion, saving the parking and having that added level of safety is important. I'm not against bike paths if that works out, but the extra $1 million for one block of bike path seems a bit excessive to me. But that's just my opinion. Anybody else have any thoughts? Thank you, Mr. Karinko. Item 2.9, cost participation and maintenance agreement, 8349 shared use path from 32nd Avenue South to South 48th Street, somewhere to South 48th Street.
Oh, yes, Heartland Drive, that is located just west of the interstate.
Right.
So this project, it's an existing gravel path. We've got, once again, TA funds, so it's 80% federal, 20% local. These are for construction costs only. We've got about $236,000 in federal funding for this project. This agreement is our standard agreement with the DOT, and just moving forward with the project, staff is recommending approval of cost participation, construction, and maintenance agreement.
Move approval by Kavami, second by Weber. All those in favor signify by saying aye.
Aye.
Opposed, same sign. Motion carries unanimously. Item 210, bids for project, thank you, Mr. Krinkle. Good evening. Bids for project 8361 bus shelters. Good evening, Mr.
Good
Berger.
evening, President Sandy and members of the committee. What this project is we're going to be putting in some bus shelters along University Avenue with the new reconstruction that they did in the university campus area. The bids actually we ended up getting were a lot less than what we had expected because we had applied for additional funds to do down University Avenue with the Downtown Development Association to make it all one. So with that, what we're looking for is approval to go ahead and do all 7 shelters and the amenities that we would need for those areas, and it would be no more than $136,000 total bill.
How much were you thinking it was going to be?
We figured just those 4 shelters would be $136,000.
Wow.
And that's why we applied for an additional $120,000 on the next grant. So that's why we said it shocked us at how low they came in. And we did only get the one bid from Toller Manufacturing that could meet it. One of the companies could not meet the Buy America, which we are required to have 80% Buy America steel in the items. And the other one looked at it and they could not match the specs.
Great. Any comments or thoughts?
This is great news. Move approval.
Moved by Kavami, second by Mott. Any other comments? Hearing none. All those in favor signify by saying aye.
Aye.
Opposed, same sign. Motion carries unanimously. Thank you, Mr. Bergman. Good job. That's fun. Item 211, last but not least, COVID vaccination plan update. Mr. Dulitz, good evening. Thanks for coming tonight.
Council President Sandy and members of the committee, I'm Michael Dulitz with Grand Forks Public Health. We're going to have a 2-part update today. First, we're going to talk about dashboard changes to the health officer dashboard, as I alluded to last week. And then second, we'll be talking about our vaccine strategy for this summer. So, as I alluded to last week, we've been having some issues with the health officer dashboard being relevant to the actual COVID condition in the community as our vaccine rate increases. We're having issues with it moving into yellow, which was having some minor policy implications, such as kids having to wear masks outside at school, things of that nature. So we want to make sure to update the health officer's dashboard to reflect the current conditions in the community. So those changes, there's 3 major changes. First, we're going to add the vaccine rate as a score modifier to the dashboard. So essentially, the score that was there before, we're going to minus the vaccine rate for the community, and that's going to be our modified score, which is what the color level will be derived from. we're going to increase the size of that red category. The reason why we increase the size of the red category is we don't want to lose the, by subtracting from the score, we don't want to lose those kind of critical levels that we could potentially run into if there was, a critical situation at the hospital related to COVID cases, combined with the high case rate in the community. Wanted to make sure that we preserved that part of the dashboard. And then finally, we changed the category weights. We put a lot more emphasis on the hospital capacity as being 40% of the score, along with the new case rate, because both of those would be drivers of potential problems in the community related to spread or related to impacts on capacity in the community. Testing isn't as important now because we don't want asymptomatic people, or we would more discourage asymptomatic vaccinated people from getting routinely tested because that increases the chances of false positives and things like that. And percent positivity and percent change still do have a role, but it is a relatively minor role now given the larger amount of vaccination in the community. So when we look at the health officer's dashboard, for today, we were very firmly in the green with a new case rate of about 5.3 cases per 100,000. That is significantly lower than where we've been at for about the past 2 months. So this is about where we were at the beginning of March. But we have seen a decrease in testing. So this is, this was one of the things that prompted us to change the dashboard. So changing that, or with the dashboard changes, we're at about a 40% vaccination rate. We would have to round for that. That puts us at a modified score of 0.1. Again, for the final score, we round to the nearest, 0.1 digit. So that would put us firmly in that low risk category. Over the past 2 months, we would have bumped up into the yellow, but not up into the orange like we were for 5 days in April. Looking at the difference in score, that orange category is a little bit smaller, the red category is a little bit bigger, but the low risk and moderate risk categories are about the same. This is just an information-only update, but I did want to give a chance to share this in an open forum as well, so we can save questions for the end if there are any. In addition, there is still the normal dashboard update that's included in your agenda. Now moving over to...
Mr. Jules, I'm sorry, can you go back one slide, please?
Sure.
I just wanted to call the attention to make sure it's clear that although you changed the red level, the score, how it's derived remains the same, and you end up with the score as you showed, and then the vaccination rate is subtracted from that, correct?
Correct.
That's how you get your modified score.
Correct. So
Yes.
the scoring is the same aside from the changes in weights, but it uses essentially the exact same criteria. But then we just subtract the vaccination rate, owing to we would have potentially more dead ends of spread in the community. So there would be fewer chances for COVID to be spreading the higher our vaccination rate is. And so that was the logic behind subtracting that number. Essentially, the people that are susceptible or vulnerable to getting COVID infection are a lot smaller. That pool is a lot smaller because we have more people that are vaccinated in the community, roughly 28,000 people smaller of a pool. So that's the logic behind reducing.
Right, which also lends to the logic of why the severe risk category grew so much, because even with the vaccination rate the way it is, if our numbers get into the severe category, we're in real trouble.
Yeah.
Right, so I can understand, because you go from moderate risk to it's really bad really fast.
Yeah.
Yeah, and that makes perfect sense to me. I just wanted to make sure that people at home recognize that there's some good logic behind what you've done here. Thank you. Mr. Weber, did you have a question?
Thank you, President Sandy. Yes, Mr. Dulitz, both you and Ms. Brune, I think we could kind of grow numb to this. We just see it daily, weekly. But this has been an incredibly important tool. Thanks for all of your work over the months on this. I'm guessing that Dr. Walls, our public health officer, he was deeply involved in these decisions as well?
Yes, he was.
Very good. Thank you. Thank you both.
Yeah. Okay. Thank you, Mr. Dooley.
And now moving over into our summer vaccine strategy. So I have Haley Bruin with me. She's the vaccine program manager, Grand Forks Public Health. And we're just going to touch a little bit on what our plan is for vaccine for this summer. So looking at our vaccine rate as it is today, we're at about 40.7% of the community that has received or is considered to be fully vaccinated. So again, that's about 28,000 people in our community. And to reach that, that threshold where we consider ourselves to have presumptive herd immunity, we'd be looking at needing about 44,000 people. So that leaves us at about 11,000 people short of a pool of about 28,000 people that are still vaccine eligible in the community. So we have to get about 40% of those people still vaccine eligible to get the vaccine this summer. Looking at where those groups are at, we still have a lot of people in that 18 to 64 age group in the community that have yet to be vaccinated. When we look at the 65 plus age group, though I don't have a slide, we are doing phenomenal in that age group with right around 90% of that age people in that age group being fully having at least one dose of vaccine. When we look younger into the 12 to 17 age group, this is an area where we can still reach people. So this group is probably less than 10,000 people, but it's still a group that is used to getting vaccinations. They may have some fears and hesitations with it, but the biggest thing is they're used to getting vaccinations. One of the big hangups is that we have to consider parental consent, things like that, in order to get that group vaccinated. And unfortunately, we're also dealing with a changing strategy for COVID vaccination. So we got all of those low-hanging fruit right away, the people that were going to, one, make an appointment, and two, come to us to get vaccinated. At the Alaire Center, we did over 37,000 doses there. But just as quickly as we kind of hit our peak, we also kind of fell out of that peak, and now it feels like we're kind of falling into a new normal where, instead of doing thousands of vaccines a week, we are happy when we can get 100 vaccines in a day. So we had to think about what kind of strategy would help get us at least a good 100 people per day, somewhere around there in the community, so we can hopefully get a better path towards that herd immunity. So we were thinking about things like motivation. A lot of people that we've been catching at vaccine opportunities lately, it's just, I thought I'd get vaccinated at some point, I just wasn't motivated. They may have transportation difficulties, they may have some hesitancy, they may not have time, or parental consent could be a barrier. We've also looked at some tools that were put together to help us look at different vulnerability and other indices based off of census tract. And we did identify one of the areas that kind of pointed out to me as one that I wouldn't have immediately thought of, is that kind of area bound by Columbia, Washington, 17th, and 32nd. That was considered to be the most vulnerable spot in the community and has about 8,800 population, I believe. And then there's still pockets of transportation or household vulnerabilities throughout the community. Then we looked at our current vaccine partner locations. So we looked all around our community, who is offering vaccines, how are they offering them. We do have a good number of vaccine partners that are providing vaccine for us, but they kind of all coalesce around similar areas. It's hard to get good spread throughout the community. So that's how we kind of came up with our goal. So our goal to help kind of fill in the gaps in the community, looking at how we vaccinate people, is to provide a vaccine opportunity within a half mile of 95% of the Grand Forks community. When we look out into the county, we want to provide a vaccine opportunity within 10 miles for 95% of the whole county, but we want to go within a half mile for the city. That should be around a 10-minute walk, and that 95% is, we're very close to that. It's about 2,000 people that we don't have within that half-mile walk. Those are either in locations where it would be roughly an 18-minute walk, not that much different, or it would be a highly mobile population, such as the south of the city. So looking at our proposed vaccine sites, the proposed sites are in green on here. Some of these sites, as we will get into, will be reoccurring sites where we'll be there every single week. Some will be provided on a rotation, but we do intend to have at least 2 opportunities this summer at all of the spots in green. So looking at our proposed vaccine locations, these are the vaccine locations that we had put up. So we're looking at all the ones in green are the ones that we'd be looking at, and these are all these are all suggested areas that we'd be looking at, and then the population within a half mile. And I'll hand it over to you for more details on the plan.
Thank you, Michael. President Sandy and members of the council, good evening. My name is Haley Bruin. I'm the Immunization Program Manager at Grand Forks Public Health. I've been our on-site incident commander at all of our community clinics in the Alaris Center, which we've been very proud of. As we move into this next phase of vaccination, we really saw ourselves as being the chief health strategist for what would be the next phase. And in looking at that role and discussing what's really driving people, right now convenience is the major driver for people in getting vaccinated or not. We wanted to put sites where people would essentially almost trip over them, making it so easy for people to be somewhere where they're already going and not having to make any additional appointment or stop. We often think about people having 3 places that they primarily go. For me, it's work, home, daycare to pick up my kids, or school. And so if you put a vaccination site in the path of one of someone's 3 places, inevitably you're making it incredibly easy for them to stop along the way and get those vaccines done. As Michael said, parental consent is huge. So now not only do you have to get an adult vaccinated, but you have to have a minor aged 12 to 17 along with a parent to be vaccinated. And so we set up these sites, making it incredibly easy, hopefully, for parents as well. So that's how we kind of came up with our proposed locations. We plan to run a 2 4-week rotation, along with having some fixed sites. So here's our schedule that we're proposing. This will kick off in early June. We're actually having our kickoff event at the Home of Economy Food Truck Fair, and then having some fixed sites every week along with a rotational site. We plan to work with our communications committee on how we market this out to people. We want to make it very visible for people so that we can engage them along their route and get them vaccinated. We did launch our mobile vaccine unit last week. So it is a travel trailer that we take around. We did our first event at Home of Economy, and we were able to do 42 vaccines in 4 hours. So the turnout was better than expected. People came out. Home of Economy was great partners. They graciously offered an incentive for people, $10 off of 50 if they wanted to shop in the store. So that was a great partnership, one that we haven't had before. And that's kind of the nice thing about this, is there are some unique and new opportunities for partnership between public health and some of the private businesses in our community. Hugo's also has been very great to work with. That site at the old Alaris Bank inside the store has been a wonderful opportunity for us to reach people. So as you can tell, though, this is a big endeavor. So there are a lot of opportunities in this for us to partner with other community partners, those who are also giving vaccines. At the beginning of COVID vaccination, private businesses and healthcare entities had the opportunity to become an enrolled COVID vaccine provider. Through our process of centralizing at the Alaris Center, we took away the opportunity for some of those businesses to reach their own low-hanging fruit, their clientele that already would come to them, and we vaccinated them through the Alaris Center. So we see this as being an opportunity for those partners to get involved and to still help us with a really important endeavor, which is getting everybody vaccinated for COVID. So we will be working with them. We've sent that invitation out, and we're waiting to hear back on some of those partnering with us. And we would certainly, provide them with the support that they need to be successful at some of those sites as well. And like we said, we are at Hugo's on 32nd. We were just there today. We'll be hosting a site at the Grand Forks Public Library this week. We'll be there from 2 to 5 on Wednesday. We'll resume at Home of Economy from 10 till 2 on Thursday, and do another site at Hugo's on 32nd from 2 to 6. And as I said too, we market all the events through our communications committee. Having this plan kind of gives us some lead time to engage people with mailers, next door, neighborhood signs, just to really get that word out. And so that is our plan moving forward for the summer.
Great. Any comments or questions? Mr. Weber?
Thank you, President Sandy. I perhaps had mistakenly believed that misinformation was a major problem. You're finding that it's convenience and motivation, and that's perhaps easier to address, and it sounds like you have some really great strategies for doing so.
Yeah, absolutely. When we talk about vaccine hesitancy, there's always, for every vaccine, there's 3 different groups of people. There are people who are going to get it no matter what because they trust science and health professionals and their opinion. There are people who are probably going to get it, but they just need a little bit more information. This strategy also allows us to reach those people. Not everybody has time to make a primary care appointment, although that's a great place and one of the best places to connect people with vaccination, but not everybody has that opportunity to make the appointment to just go to their doctor's office and visit or ask some general questions that they have. Having our highly visible mobile unit will allow people to connect with a healthcare provider at that site and ask questions to determine if it's right for them or not.
That's optimistic news. I'm very glad to hear that. I saw a word in the presentation, booster. At what point do we have to start thinking about a booster? How long is the current vaccine good for? Do we have any data on that yet?
At this time, I have not heard of any booster recommendations
Oh, I
yet.
just made that up that I saw that word. I thought that I saw it.
Councilmember Weber, that's in there as a booster, as in a second dose. So
Just the
first and second
I
dose.
I
yeah.
see.
Oh,
Okay.
got
Okay.
it.
Very good. Just one final quick thing. I didn't mention Nerisse in my thanks earlier. So thanks to Nerisse Nicolette for all of her work as well. Thank you.
You're welcome. I'm a generally skeptical person and skeptical of everyone. In this situation, I'm not skeptical at all because I believe in the dollars and cents of it, knowing full well that there's literally billions, if not trillions of dollars at stake for the pharmaceutical companies that are making these vaccinations. And if they actually had issues, it would mean such significant detriment to those organizations. They would not put out a vaccination that isn't healthy and whatever and effective. So I also believe in the science too, but I believe in the dollars and cents and know the motivations of these pharmaceutical companies. Mr. Weigel, comment? Thank you. Yeah, Mr. Kavama?
Is there any thought to going to like the Greenway Takeover or sporting events? I know that there's going to be some things this summer. I think that maybe that might be a good opportunity. And then also, speaking with my peers that serve on other city councils, they don't get the level of data that we get. So thank you too for that. It's amazing. I sent it to them and they're like, how do I get these people to work for us? So don't. So.
And personally, my son runs a concession stand as a 16-year-old. Because of that, he's licensed through the Department of Public Health, and he got a phone call saying he's eligible to get the vaccination, and of course, he mentioned that his twin sister works for him, and so through one phone call, my twins got vaccinated right away, and it was great. I'm very, very happy that they did. And they're spreading the news to their classmates that they should get vaccinated as well.
Absolutely, that's wonderful. And on the note of special events, we do have some special events as part of our plan as well, so we are looking into those too.
So thank you both for all your hard work. I know it's this is a labor of love and everything else, so this certainly has been quite an endeavor. Any other comments for our folks from the Department of Health? Thank you for coming in. Appreciate the update. And again, on all the hard work on the dashboard, very logical, makes perfect sense, so I really appreciate it.
Thank you.
Anything else? Yes. Anything else for the good of the order? Yes, Mr. Weigel?
I move we adjourn.
Move we adjourn, second by Weber. All those in favor signify by saying aye.
Aye.
Opposed, same sign. Motion carries. We adjourn. Thanks, everyone.